They didn't just threaten to sue me, they actually sued me. And the case came to a conclusion in the High Court last Monday. This case took 1 year and 4 months from receipt of the original letter from the solicitor and a High Court hearing before the solicitor would finally accept that that original letter did not adequately set out his client's complaints, which I had said all along. Not only that, the solicitor admitted in court that he did not fully understand his client's complaint at the very outset, and yet they snowballed and ran on with his case regardless. As it turns out, part of the underlying complaint was in relation to separate videos posted by the first defendant which were nothing to do with me and were not contained in the first letter to me. And it's at this point I'd like to make absolutely crystal clear a caveat to this video. And that is that whilst I'm a champion of free speech, this video is in no way intended to shame or ridicule the company or its directors or the solicitor involved. And whilst it's not for me to tell you what to do, I would expressly discourage you from leaving nasty comments and certainly refrain from contacting the company directly. That is absolutely not the intention. I discouraged that in my previous video, and yet they sued me anyway on the basis of comments left by other people. So please don't do that, but this video of mine is absolutely in the public interest to explain to you how this process worked, how it can turn your life upside down, and how you might deal with it. And so with that, let's get into the story. This is the story that I've been promising to tell you about for some time. I have withheld from talking about it so far, out of respect to the court and the legal process. In hindsight, maybe I wouldn't do that next time, but here we are. That's what I chose to do. But this is that story. So instead of accepting responsibility and apologizing, and the whole thing might have gone away relatively quietly, in my view, this company sought instead to, first of all, to threaten litigation, then actually bring litigation in the hopes that it would silence me and the cyclist involved, which I'll explain in a minute. And eventually they tried to buy my silence, which I'll tell you about in a minute as well throughout this video. But ultimately, I said no to the money and to be silenced, which is why I can now talk to you about it on this channel. Because I am a champion of free speech. I believe that we have and should protect the right to free speech at all times. It is a very high bar that will have the state or the courts interfere with our freedom of expression. And that is what I aim to tell you about in this video. Now, you may remember, if you cast your mind back to the very beginning of last year, the 1st of January, I published a video where a company was threatening a cyclist with trademark infringement because he filmed the van driving past him too closely with the name of the company on the side of the van. The driver was prosecuted, and there was a bit of a to-do between the cyclist and the company about whether or not this was trademark infringement. I did my video to explain that it was not trademark infringement, and in fact threatening trademark infringement where it didn't exist, didn't arise, could amount to unjustified threats. So if you incurred legal costs to stop them from threatening you, you may be able to claim those costs. It usually applies to marketing other goods and vague threats that have no real basis, but that's entirely another matter. But then they threatened to sue me, at least vaguely, because there wasn't any real cause of action disclosed properly within that letter. I then did a video about that letter, explaining what I thought about that letter, because in my view there was a veiled threat at the end of that letter, but you can go back and watch that video to hear more about that letter itself. Now, I'm very sorry to say that there is no polite way of putting this. This case was a mess from start to finish, right from the original letter, because the original letter conceded that the original trademark threat was misconceived. It expressly said as much in the original letter in the bit in orange. It says, "My clients accept that the original threat of infringement proceedings in his email was misconceived. It misstated the law and should not have been made." However, the purpose of this letter is to examine your role here, mine in doing the video. Now, I have to say, for full transparency, that the solicitor then did give different advice to the claimants, and they rolled on with the claim anyway. Now, there's lots more to get through. I'm going to show you the claim form, more about the allegations against me, which I took really personally. So more about those in a moment, but first of all, a word about a sponsor who supports my channel in supporting free speech here. Don't go away. Just as an aside with a really important update, well, two important updates really. First of all, there's been a major password leak with 184 million passwords leaked, believe it or not, in plain text and published online. I'll tell you why that is so important in just a moment and what you can do about it. But this, as it says, is staggering. The key buzzwords here are unencrypted, unprotected, unbelievable. But also, that's not the only thing. Also in the news is possibly, I think, the largest data breach ever with over 4 billion with a B. Now get your head around how many numbers of records that is. Over 4 billion records have been leaked in what is quite possibly the largest data breach ever. Now, why is all this important? Because you have your data stored with lots of different companies, marketing companies, companies you've worked with, bought stuff from, they've sold it on, shared it, and so on. Now, all of that information is stored somewhere, and these passwords and leaked records, etc., might give people enough information to access that information and then build up a picture of you and impersonate you and take out loans and credit cards and mobile phone contracts and wreak havoc on your life. That is absolutely devastating. We've had clients at the firm who've been through that process and it turns their life upside down. Some of them even end up on the fraud database and they can't even get a mobile phone contract. So what do you do about that? Well, there are companies in the middle that are data brokers and marketers that will gather all this together and start selling it over and over again. And your data will be stored on various servers. So what you can do about this is use a partner of mine, which is Incogni, which will contact all of these companies that store your data in the UK, in the US, using UK law and US data protection law, and require that they remove your data from their servers, thus preventing these hackers from using the password and getting access to all the data and impersonating you. You get a 60% off an annual plan using the code BlackBelt. Just go to the link here, incogni.com/blackbelt. Make sure you use the code BlackBelt and that it's applied. That'll get you a 60% off. If you sign up on the family plan, you can use up to 5 email addresses. So all of your family can do this as well to remove all your data from their servers. And there's also just recently launched a custom removals so that you can ask Incogni to remove data from specific websites that you might know your data is stored on, but don't want to go through the whole process of doing it yourself. So check out Incogni with the discount of 60% off the annual plan using the code BlackBelt, and this will help to keep you safe. Now, aside from the obvious redactions of names and addresses at the top and the bottom of this claim form, the middle section was the claim that we had to meet. And as you can see from the bits of red, the bits of black, the smudged bits and the pen ins of different words, this was, to put it quite bluntly, an incoherent mess of the claim that we had to meet. But then they further particularized the claim against me, against both of us as defendants, and they claimed as follows: damages for harassment limited to £20,000. Now, this was largely particularized as a result of comments left by third parties. They said that we had conspired to harass the claimant in this case by encouraging or inciting ridicule and horrible comments. Now, all of which I do not condone, I do not encourage, and as per my caveat, I expressly discourage anybody from making such remarks and especially from sending any remarks. Again, do not do that. But it was the very nature of these allegations of harassment against me that I found particularly insulting and offensive, especially given they sought to stifle my right of reply, my right to publicly defend myself against these spurious allegations, especially now that there is a judgment in the public domain with my name on it, with all of these issues circling underneath it. And the only resolution to this case is they essentially threw the towel in. They say for commercial reasons that it wasn't viable taking it to trial. I'll give you what I really think about that on my other channel, my new Off the Record channel. I'll link below. But do subscribe there. But let's focus on this just for a moment, because I do feel the need to have to say something about this. They put in the particulars of claim here that the defendants, so including me, posted the vlog, so presumably my original video, and maybe the second one where I'm talking about the letter they sent to me, must have known that the vlog would lead to xenophobic and or racial hostility towards the first claimant, who is of Polish origin. Now, I feel really silly to have to say this, but I will say it publicly because that judgment is now in the public domain. One of my best friends is Polish. I train with him in Taekwondo. I spent many hours discussing things with him, helping him wherever I can. My wife is Chinese. One of my best colleagues is Syrian and Trinidadian. And I also have friends and colleagues who are Muslim and all sorts of different faith. So I find it a bit silly that I have to say that in any kind of defense. I saw something the other day that when someone accuses you of being racist, the best response is just not to respond because it doesn't deserve an answer. That's how I feel about it, but I do feel at the same time that they've put this out there. So those are the facts. This is the least likely thing anyone could ever or should ever really accuse me of doing. Nonetheless, they put that in the particulars of claim here, and they said that the defendants are liable for their conduct, as in the conduct and the comments of third parties, by a common law duty of care, which is wrong, by the way. But they say the postings of end users on their respective channels, the defendants are vicariously liable for the damage caused to the first claimant by the defendant's end users' virtual mobbing and trolling of the first claimant. All of this goes back to those comments that I said you shouldn't post. They are trying to say that I am responsible for those comments, but as a matter of law, I am not responsible for those comments. In fact, to quote Deputy High Court Judge Eardley KC in the claimant's unsuccessful application for this injunction, he said as follows at paragraph 42 in respect of the third-party comments. He said, the bit in yellow, the fact that some extreme and unreasonable readers might seize upon the claimant's name to make racially abusive comments, as regrettably they did here, cannot be held against the first defendant. To do so would be a very far-reaching and unjustifiable interference with freedom of expression. Now, obviously, this was against the first defendant because I had agreed without any admission of liability to take down my videos pending final resolution of the issues in this claim. And obviously, as the case was discontinued in full last Monday, my videos are live again and I am free to talk about it. There was never any strict restriction on me talking about it, I just chose not to do so. Secondly, there was a claim for damages limited to £1,000 for breach of GDPR for alleged unlawful processing of the first claimant's personal data. And as I stated in my defense, I didn't process any data, unlawfully or otherwise, because I didn't mention his name. Thirdly, they claimed damages for trademark infringement, including special damages limited to £50,000. Now again, for all the reasons I said in my very first video, nothing in my video was trademark infringement, referring to matters as they unfolded. The fact that the name appeared on the side of a van is not trademark infringement. Fourthly, they sought a permanent injunction restraining both the first defendant, cyclist, and me from doing any of the following, whether by directors, officers, employees, servants, agents, or any of otherwise stated. Firstly, from infringing their European trademark, which, as it happens, is no longer enforceable in the UK post-Brexit. I think they do have a UK equivalent trademark, but that wasn't pleaded as part of the case. They pleaded the European trademark, which is not enforceable in the UK post-Brexit. For sub 2, I'm not quite sure why this was under the injunction bit, but sub 2 asked for an inquiry as to damages for passing off. Sub 3, an order for payment to the claimant of all sums found due. Sub 4, an order for the dissemination and publication of any judgment where the defendants found to have infringed. And sub 5, interest on special damages. And at one stage, the solicitor for the claimants in this case wrote to the solicitor for the first defendant, cyclist, and said as follows. With regards to the second defendant, the matter has already been resolved amicably on settlement terms that serve the interests of both parties. Your client, the first defendant, is not entitled to the terms of settlement between our clients and the second defendant. But of course, that was not true. We had not settled the case and did not settle the case. They discontinued the case by way of application at the High Court last Monday. The only thing they did agree eventually was the costs, which otherwise they would have been going to detailed assessment, which may have resulted in higher costs. It may have resulted in lower costs, but they agreed to pay a fixed sum of costs in a given time frame. But I maintain, and it is my view, that the primary objective was to take down these videos because they drew attention to what had happened. Now, my first video was obviously to illustrate the law that it was not trademark infringement, and the second video was frankly to talk about the letter threatening to sue me without really disclosing a basis of a claim and conceding that the original trademark threat was misconceived. Now, you may have noticed that both of those videos disappeared for a short time. That's the reason I didn't have to attend the hearing for an injunction, because they applied for an injunction against both the cyclist and me, asking the court to make an order that I be forbidden, whether by myself or instructing or encouraging or permitting any other person, to refer to the director of the company, directly or indirectly on YouTube, on my channel, or any other social media channel. In other words, and on my interpretation, this case was a slap, a strategic lawsuit against public participation. In other words, they wanted to silence me through litigation. That is my interpretation. That was the substance of my defense, and I was having none of it. I believe this case was a slap because right from the very first letter, what they sought to achieve was taking down my videos from YouTube, when all the while I had only talked about the trademark issue in the original video. In my second video, I talked about the letter that was threatening me, but even that letter was heavily redacted. But as you can see right from this very first letter on screen right now, the bit underlined in red, they requested that I take down the second vlog. That was my first video, in its entirety within 7 days. I took this as a cease and desist letter, of which I've received many, and to which I need not reply, because as I explained in my second video, that did not amount to a proper letter before action, because it did not adequately disclose the client's complaints, and it did not set out a cause of action. And the solicitor ultimately, when pressed by the judge, accepted as much in court last Monday. The second reason I believe this case was a slap was the application for an injunction, which in essence sought the same thing. You can see here, referring to the cyclist and then to me, they sought an order of the High Court that I'd be forbidden, whether myself or instructing or encouraging or permitting any other person, to refer to the director or the company directly or indirectly on YouTube or any other social media. Furthermore, in their final application to the court to discontinue this case against me, it was still very clear, to me at least, that their primary objective was to restrain me from ever mentioning this company again. And in their application to the court to discontinue the claim against me, whereby the ordinary rule says they pay my costs, more about that later or in another video, they put in the application the following. The solicitor wrote that the claimants had made several open offers to me, the second defendant. And then from the third paragraph down, the solicitor wrote that he re-emphasized that they are settling the case not due to a lack of merit, but rather on a cost-benefit analysis. He said, "It does not seem commercially viable for our client to take this case to full trial. So it is in our client's best interests to reach an out-of-court settlement." Bearing in mind this application was to discontinue the claim against me. They then wrote, the bit in orange, "As instructed by the claimants, I offered £40,000 inclusive of costs and VAT to be paid within 28 days. Maintaining the undertaking not to use the mark and the name of the company or any confusingly similar in relation to any videos or written material except for those not misleading and do indeed relate to their client's business." Additionally, it says claimants, I presume he means second defendant me, should continue the undertakings agreed by consent, because they were my undertakings I agreed by consent, on the 19th of June 2024. It says as recorded in a sealed order of Deputy High Court Judge Eardley KC, although it later transpired that that was not sealed in any event. The solicitor then said in the application that he called my legal representative, which is my learned friend Alan Robert Shaw of Art of Law, and yes, it rhymes, pop over and do subscribe there. And then they increased the offer to £50,000, inclusive of VAT. However, that obviously required that I never mention them again, I never do any videos about it, I never talk about it, and I just stay quiet. And then they say that I declined to address the matter on this basis, refusing all reasonable offers. And therefore, they say that my stance was unreasonable. But what I say is unreasonable is having litigation brought against you, which in my view had the primary objective of taking down my videos, right up until the end, saying that I'm unreasonable for not accepting their money, for not talking about this incident, because I want to maintain my free speech. I am not in the business of selling my free speech. And so I disagree that it's unreasonable for me to refuse offers of money to restrict my channel and what I say on my channel to help you understand law. I told you at the very outset that that's what I intended to do, and I intend to keep doing that. Now, I emphasize, none of this video is intended to ridicule or shame the company or its director or the solicitor, but I believe that this was a very poor choice to sue me, and the cyclist for that matter, over this matter when they could have simply apologized on behalf of whoever the driver was driving the van, driving badly, who was prosecuted by the police. But this is precisely, in my view, the kind of case that the Solicitors Regulation Authority, the body that regulates solicitors, put out a warning notice about, where they say in the summary of key points that strategic lawsuits against public participation are a misuse of the legal system through bringing or threatening claims that are unmeritorious or characterized by abusive tactics in order to stifle lawful scrutiny and publication, including on matters of corruption or wrongdoing. They say that their key message for solicitors and law firms are that you must not bring or threaten unmeritorious claims or engage in tactics that are intimidatory or otherwise oppressive, that your duty as a solicitor is in your client's interests must be balanced with your wider professional obligations, including your duty to the courts and uphold the rule of law, which take precedence should these come into conflict. They say you should identify proposed causes of action or behaviours which comprise a slap or abuse of the litigation process, and decline to act in this way. Particular care is required where publication ventilates a matter that is likely to engage the public interest. So I maintain that this was such a case. It was a slap, which by that definition is a misuse of the legal system based on an unmeritorious claim in order to stifle lawful scrutiny and publication. That is my view, that was my defense, which I'll go through in greater detail in a separate video. So I genuinely hope you find this video useful, because I suspect this will be more and more common with people being threatened with a lawsuit or actually sued because they publish something online that somebody else doesn't like. Now, so long as you're within the bounds of the law and what you say is not harassment, that it does not cross this fairly high threshold of what will become harassment, it needs to be grossly offensive, oppressive, unacceptable, that sort of territory. Or if you say something that is defamatory, you need to have a reason for it, a defense for it. For example, it could be the truth, it could be your opinion, or it could be public interest, etc. So long as you're within the bounds of the law, we need to protect free speech. And that is why I've held out to retain my free speech here. And that is why I bring this video to you. For that, please do subscribe to the channel. I thank you for watching, and I'll see you next time.